Hi, I'm Las Vegas bankruptcy attorney Ryan Alexander. Today we're going to be talking about what Chapter 7 bankruptcy can do for you and how the Chapter 7 process works. A Chapter 7 bankruptcy is called a liquidation or standard bankruptcy, and it's a single process that would eliminate your credit card debts, your debts from foreclosed homes or homes that you're going to surrender. It would get rid of medical debt, payday loans, lines of credit. You can cancel contracts, you can get rid of certain taxes, and you can also get rid of the debt of repossessed or surrendered cars. So if you're currently making a car payment and you want to get rid of that car, you can do that through the Chapter 7. Or if you've already surrendered a car or had a car repossessed, that debt would also get eliminated by a Chapter 7 bankruptcy. The process of a Chapter 7 bankruptcy takes about 5 months. Another strength of the Chapter 7 bankruptcy is the automatic stay. This means that from the day you file your bankruptcy in bankruptcy court, no creditor can take any collection action against you, and all lawsuits have to stop against you. This also means that any foreclosures that are pending would stop, and any garnishments from your bank account would stop, even tax or child support garnishments or levies, even though those in particular can't be discharged. But you would get a period while you're in the bankruptcy proceeding to resolve those accounts. But the thing to remember is that from the day of filing your bankruptcy case in the bankruptcy court, you get the power of the automatic stay to protect you. Now, it's also useful to discuss the things that Chapter 7 cannot do. Chapter 7 will not change the amount you owe on a mortgage or on a car payment that's secured by the car. It would also not change any furniture loans or jewelry loans if those are secured by the items that are being financed. Those are called secured debts. Chapter 7 is meant to deal with unsecured debts. Also, we cannot discharge taxes that are less than 3 years old, or child support or alimony debts that are owed under a court order. Like I touched on earlier, those would be stayed pending your bankruptcy but would not be resolved by the Chapter 7. And if those are your primary debts, we would probably talk to you about a Chapter 13 instead. But it can eliminate older taxes, and it can also get rid of mortgages from houses that you've either foreclosed on already or short sold and there was a deficiency, or you intend to give back through the bankruptcy process. That's called a surrender. And if you surrender your house or a vehicle that you're still making payments on through the bankruptcy process, then those debts would be eliminated as well. Now, unless you're a disabled veteran or your debt is primarily commercial debt, there are limits as to who can file for Chapter 7 bankruptcy. This is determined by the median income for the state you live in. Now, we're in late 2012 in Nevada. This would be about $44,500 for a single person, or about $67,000 for a family of 4. And how that is calculated, they're going to look at your income for the last 6 months and determine whether your rolling average income exceeds those numbers. And again, unless we can show that you are a commercial debtor or you have another special exemption under the bankruptcy code, if you don't qualify under that median income number, then we'll have to look at either a Chapter 13 bankruptcy or a Chapter 11 bankruptcy, both of which would be a payment plan bankruptcy rather than a single process liquidation bankruptcy. Now, although it's called a liquidation bankruptcy, Chapter 7 for Nevada residents is actually very generous in that Nevada has some of the best exemptions to bankruptcy in all of the U.S. In fact, probably only Florida and Texas would be comparable. What this means for people in Nevada filing bankruptcy is that you can keep more of your stuff. In fact, most of my clients keep all of their personal property. There are only a few things that are not covered in or not exempted from a Chapter 7 bankruptcy. These would include raw land, paid off rental homes or other investment properties, boats, motorcycles, ATVs, all-terrain vehicles, dirt bikes, and recreational vehicles and timeshares. Those are the most common things I see where I have to tell a prospective client that they would need to sell those assets before filing, if possible, or we would have to figure out what the value is and expect that you will have to buy that asset back out of the bankruptcy estate after filing. We'll discuss that more in person, but what that would mean is if you had a motorcycle that was worth $5,000 and you wanted to keep it and you couldn't sell it for fair market value before filing, you have the chance to buy that back from the bankruptcy estate, but you would have to come up with a payment for the trustee or a very short payment plan in order to buy that back. However, otherwise, most people do not have to sell anything or give anything away. And I advise you not to make any moves and sell any major assets before you come and have a consultation with me. And we'll discuss how we can plan to maintain as much of your assets as possible or sell off any assets that you can't keep anyway. If you're considering bankruptcy, you should get together 3 years' taxes, 6 months' bank statements, 6 months' pay stubs, a statement from your current life insurance policy, and if you have an IRA or 401k, a most recent statement from your IRA or 401k. Those will be the things that we'll need to file along with my questionnaire packet, which I'm going to have you fill out. So I'm going to have you fill out a packet, and we'll go through that together. But aside from that, I will need those things. Also, if you've been divorced in the last 4 years, I'll need your divorce decree as well. Once you have that information and you've filled out my questionnaire, you'll take a credit counseling class on the internet. This is a 90-minute class on finances, credit, debt, how to responsibly manage your money. And after you finish that course, you'll get a certificate. When we get that certificate, we have the questionnaire filled out, and we have the materials I just discussed, tax returns, pay stubs, bank statements. We can get your case ready. It takes us about 1 week to get a case ready for filing. When we submit your case to the court, you will have one interview in 5 weeks from the day we file with a trustee. Now, a trustee is a bankruptcy attorney who has a contract with the government to review cases. And they're going to look at all the paperwork that we've submitted, and they're going to review it and make sure that you've been truthful and accurate. They'll have some background material from other government sources that they'll match up and make sure that you're telling the truth. If they see that you're telling the truth, they're going to interview you for about 3 to 5 minutes. And I will be there with you, sitting next to you. And the trustee is going to ask you essentially these questions. They're going to ask if you've reviewed the paperwork that I've prepared for you and you signed it before it was filed. They're going to ask if everything on there was true and correct. They're going to ask if you need to add or change anything, that you've declared all of your assets, that you've included all of your debts. Whether you have a personal injury case right now or any reason to sue anybody else, they're going to ask if you owe any money under a court order for alimony or child support. They're going to ask if you've ever been convicted of a felony. They're going to ask if you are expecting to inherit anything from a will, trust, or estate. Or has your financial situation changed since you filed bankruptcy, that you've come across some sort of windfall of money in between the bankruptcy date and the interview date. Lately, this is late 2012, they're also asking whether you're intending to keep your house, if you're still in your house, and what you want to do with that. Several of the trustees have gotten involved in the short sale business. If you're going to surrender your property to the court, they may take that property and short sell it, which really won't have any effect on you, except that you might have less time in the house than you would normally. Because of the automatic stay, if you're surrendering the property, they can't do anything for a period of time. And what I'm seeing right now, again, this is late 2012, is that most banks are not really taking an aggressive stance like they did in 2008, 2009. And they're really not pursuing people's homes very quickly. Most of my clients now get between 4 months and a year in the home after filing bankruptcy. If you'd like to have a free consultation about Chapter 7 bankruptcy, call me, Attorney Ryan Alexander, at 702-222-3476. That's 222-FIRM.